The College of Nurses of Ontario presents Confidentiality and Privacy, an overview. This presentation is the first of two chapters about confidentiality and privacy. This first chapter provides an overview of your accountabilities for maintaining the privacy and confidentiality of clients' personal health information. The second chapter is a review of case studies and applying the college's practice standards and guidelines in situations that could result in privacy breaches. Privacy breaches are serious offenses that negatively affect the trust between nurses and their clients, as well as the public's trust in the nursing profession. As a nurse, you are accountable for maintaining the confidentiality and privacy of clients' health information. It is against the law to access a person's health information if you don't need the information to provide care to that person. The college and the government are increasingly concerned about privacy breaches and have been taking legal and regulatory steps to protect the public and hold individuals and organizations accountable when they commit privacy breaches. After watching this webcast, you should understand your regulatory accountability. Know your obligations under the Personal Health Information Protection Act. Understand the concept of circle of care and how it influences decisions about the privacy and confidentiality of health information. To understand why privacy breaches negatively affect the trust between clients and nurses, it is important to understand the elements that are foundational to nursing. We call these the elements of care. They are professionalism, ethics, and therapeutic relationships. Applying these elements of care will help you maintain the client as the focus of your care, while preserving your client's trust in you and the public's trust in the nursing profession. Therapeutic relationship is about how you interact with your client. Professionalism includes the body of knowledge you have and apply as a nurse. Ethics is about respecting your client's values. These components do not stand alone. When you apply all three elements, you make the client the center of nursing care. However, if the client or what the client needs or expects is no longer the focus of your care, then you have shifted the focus to yourself. Professional relationships are based on trust and respect. Due to the negative effect that privacy breaches have on trust between nurses and clients, it is essential that you protect your client's privacy. You demonstrate ethics by respecting your client's right to privacy, which will result in improved client care. Privacy breaches can cause emotional distress. Clients need to feel comfortable and free to communicate with you throughout the therapeutic relationship without fearing that their privacy will be breached. When your clients feel comfortable, you get the most accurate and detailed information you need to do your job of providing nursing care in the best interest of the client. The privacy legislation establishes rules about the collection, use, and disclosure of personal health information by health information custodians and their agents. Personal health information is information in oral or recorded form that identifies an individual, including details about their physical or mental health. The legislation is designed to balance an individual's right to privacy with the needs of healthcare providers to access, use, and share information. It also gives clients the right to consent to the collection, use, and disclosure of their personal health information. The privacy legislation describes the parties who have access to personal health information. These parties are called health information custodians and agents. In the privacy legislation, a health information custodian is an organization or person who is authorized to collect, use, retain, and disclose a client's personal health information. This can include hospitals or long-term care facilities, nurses in independent practice, and those employed in health services in non-healthcare settings. Agents are people who act on behalf of a health information custodian. For example, nurses are agents. Agents usually work for health information custodians, such as hospitals or long-term care facilities. In some situations, health information custodians and agents are not authorized to access or share clients' personal health information without consent from the client. To know whether you have a client's consent to access or share personal health information, you must first understand the concept of the circle of care. The term circle of care is used to describe whether a health information custodian or their agent can assume they have a client's implied consent to access or share personal health information, or if they will need expressed consent. Circle of care is not defined in the privacy legislation, but it appears in the Information and Privacy Commissioner of Ontario's resources. Before you access a client's information, ask yourself the following questions. First, is this information necessary for me to provide care to this client? If your answer is yes, then you are in the client's circle of care, and you have implied consent to access or share the health information with others in the circle of care. But if the answer is no, which means you are not in the circle of care, you should then ask, do I have the client's express consent to access and share their personal health information? If your answer to this question is no, then you cannot access or share the information. If you are within the circle of care, you can assume that you have implied consent to collect, use, and disclose client health information. If you are not in the circle of care, then you require expressed consent to access the health record. For example, if a school administrator calls you to ask about the immunization status of one of your clients, you would not be permitted to release the information without getting expressed consent from the client, because the school administrator is not within the circle of care. For more information about implied and expressed consent, read the Consent Practice Guideline at www.cno.org/standards. On May 18, 2016, changes to the privacy legislation became law. The changes included new mandatory reporting for privacy breaches. Facilities are now required to notify both the Information and Privacy Commissioner and the College of Nurses of Ontario if a nurse is terminated, suspended, subject to discipline, or resigns as a result of a privacy breach. Privacy breaches can now be prosecuted beyond the previous 6-month limitation period. Also, the fine for individuals has increased from $50,000 to $100,000, and it has increased from $250,000 to $500,000 for organizations. These changes signal that the government is serious about protecting personal health information and holding individuals and organizations accountable for privacy breaches. Nurses need to be vigilant and ensure they understand and comply with their obligations under the privacy legislation. You can suffer various consequences for breaching the privacy of a client's personal health information. The college takes privacy breaches very seriously. A privacy breach is a violation of the trust the public has in nurses. All complaints from the public or reports from employers are screened for the level of risk posed to the public, and most are investigated. A nurse who is found to have committed a privacy breach may have to pay a fine, or they could be publicly reprimanded or suspended from practice by the discipline committee. In the most serious cases, a panel has the authority to revoke a nurse's certificate of registration. Under the privacy legislation, your employer is now obligated to report to the college anyone who is being disciplined for committing or is being investigated for possibly committing a privacy breach. In addition, because the consequences of privacy breaches have become more serious for employers, the disciplinary action your employer will take against you is also likely to be more serious. For example, you could lose your job. Another possible consequence of a privacy breach is that you could be investigated and prosecuted by the Information and Privacy Commissioner. In this case, the fine against you could be as high as $100,000. Finally, you may be subject to other legal action, such as being sued privately. Technological innovations, such as social media, are changing how healthcare providers communicate. While such tools can be useful for sharing information to support client care, misuse can lead to potential breaches of personal information. One of the key challenges nurses may face is safeguarding client confidentiality and privacy while using online technologies, such as social media, to share nursing knowledge. To avoid breaching the confidentiality and privacy of clients, colleagues, and your workplace, reflect on what you are sharing. You should question whether the information you want to share and how you intend to share it are appropriate. To help employees maintain privacy and confidentiality of personal health information, organizations should ensure processes are in place for safely storing and accessing information. If you would like more information about confidentiality and privacy, these college documents may interest you. All these documents can be found on the college's website at www.cno.org/docs. This presentation has also included information from the Office of the Privacy Commissioner and the National Council of State Boards of Nursing. If you have questions about this webcast or about confidentiality and privacy in general, please contact the college. We would like to know what you think of this webcast. Please use the Evaluate this webcast link to send us your feedback.